has the stream loading on the other side, so I was waiting for him to let me know the stream was good to go. All right. Good afternoon. I am Ward 4 Councilmember Janeese Lewis George, Chair of the Committee on Facilities and Family Services. It is 3:34 p.m. on Monday, November 18th, 2024, and I'm calling this additional meeting to order. And for the record, I know we have quorum consisting of Ward 1 Councilmember Brianna Doe, Ward 3 Councilmember Matthew Fruman, and Ward 5 Councilmember Zachary Parker. We are holding this meeting via a fully virtual format, and this hearing is also being broadcast live on my website at janeeseward4.com/live. Today, the committee will consider and vote on 3 bills that will affect the Child and Family Services Agency, also known as CFSA, and the district's child welfare and foster care systems as a whole. The bills are B25-0043, the Losing Outdated Violent Exceptions Amendment Act of 2024, also known as the Love Act, B25-0243, the Child and Family Services Agency Investigation Completion Amendment Act of 2024, and B25-0952, the Luggage for All Youth in Foster Care Amendment Act of 2024, also known as Lisa's Law. We will start with B25-0043, the Losing Outdated Violent Exceptions Amendment Act of 2024. This bill was introduced by Councilmember Nadeau, along with Councilmembers Bond, Gray, and Parker on January 19th, 2023. After this committee held a public hearing on November 2nd, 2023. The bill repeals the religious exemption to the definitions of child neglect to ensure that the same definition of neglect applies to all district parents regardless of religious beliefs. Under a law imposed by Congress in 1966, before the District of Columbia had home ruled, the city's child welfare agency was prevented from intervening when a parent cites religious beliefs as the reason for refusing medical care for their child. According to the current law, any child, and I quote, under treatment solely by spiritual means through prayer, cannot be deemed neglected. This means the district cannot take legal custody of critically ill or dying child to provide medical care that could save their life or prevent permanent disability. The district is an extreme outlier in this dangerous policy. 16 states allow a court to order medical treatment, and 16 others have no religious exception to neglect laws whatsoever. The district is joined by only Georgia and Mississippi in prohibiting any state intervention in the death or disability of a child. Tragically, the majority of children prevented from receiving medical treatment under current religious exceptional law die from treatable conditions. I'm grateful to Ward 1 Councilmember Brianna Doe for introducing this bill that will undo the current policy that endangers the health and safety of the children of the District of Columbia. I also appreciate CFA's support of this bill. I will now move and open the floor to discussion on B25-0043, the Love Act. Is there any discussions on the bill or committee report?
Madam Chair.
Councilmember Nadeau.
Thank you so much to you and your staff for moving the Love Act, as well as Lisa's Law. But regarding the Love Act, adults sometimes forget that children have human rights. They forget that children are not the property of their parents. In fact, children are the most vulnerable population to exist because they must rely on adults for the nurture and guidance they need. And they're most vulnerable because they require special attention and needs in areas of their lives where they can't speak for themselves. The risk of being failed by adults is great. I introduced the Love Act last year because I recognized a critical gap in the law. Current laws allow parents and guardians to deny necessary medical care for their child if they choose to help the child through spiritual prayer instead, triggering a religious exemption. Religion can be a beautiful thing to strengthen a person's faith in an outcome they deeply desire, but it cannot be a replacement for medical treatment. Now, more than ever, it is incredibly important that our laws reflect this. This bill will put the district in line with other jurisdictions that repealed the religious exemption in their laws and saw a decrease in preventable deaths. Thank you, Madam Chair.
Thank you so much, Councilmember Doe, for your team and your leadership here. Um, we will now, at this time, I will move B25-0043, the Love Act, with leave for staff to make technical conforming and editorial changes. All those in favor, please indicate by saying aye.
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 All those opposed, please indicate by saying no. In the opinion of the chair, the ayes have it, and the motion passes. Next, we will turn to B25-0243, the Child and Family Services Agency Investigation Completion Amendment Act of 2024, which was introduced by Chairman Mendelson at the request of the mayor on April 11th, 2023. This committee held a public hearing on November 2nd, 2023. This bill extends CFSA's timeframe for completing abuse and neglect investigations from 30 to 45 days. If the allegation involves a child fatality, sex trafficking, or care in a foster home, group home, or licensed daycare facility, the deadline is extended to 60 days. The purpose of extending the investigation time frame is to improve the quality of investigations by ensuring social workers have the necessary time to collect information from and engage with all relevant stakeholders, including law enforcement, medical professionals, children, and families during all types of investigations. This bill also removes the practice of family assessments from the agency's obligations when handling reports of abuse and neglect. CFSA is currently required to conduct an evaluation to determine a family's strengths and needs, the safety of any children in the home, and a family's access to resources for the purposes of developing a service plan. However, CFSA sunset its family assessment differential response approach in 2019 and has not conducted an assessment since. The purpose of removing the family assessment from the law, which was a change made at the request of the agency, is to align the law with the agency's current practice of not conducting family assessments. I want to acknowledge any involvement with any child welfare agency, including CFSA, is likely to be traumatic for anyone, whether a child, sibling, biological parent, or other family members. This committee also recognizes forced involvement with the child welfare system has historically not been, nor currently is even applied across the district, as the vast majority of reports and investigations of abuse and neglect are made and substantiated against east of the river families. I understand why many with lived experience with the district's child welfare would oppose lengthening the amount of time CFSA has to investigate. I do not discount nor dismiss the concerns about longer time frames worsening the intrusion and trauma that arises from abuse and neglect investigations. After engaging with CFSA, attorneys, advocates, and people with lived experiences, I believe extending the time frame of investigations by approving B25-0243 will not harm the district's families involved with investigation. This is because passage of this bill will not change CFSA's investigatory practices. CFSA takes as long as it takes to conduct an investigation, regardless of the deadline, and CFSA will continue to keep an investigation open past the deadline, whether it remains 30 or be extended to 45 or 6 days, whenever the agency believes it is not safe to close an investigation. As such, this bill will not in reality extend the length of time CFSA conducts investigations, but rather will merely make fewer of CFSA's investigations technically non-compliant with the law. I also agree with the racial equity impact assessment that the bill maintains the status quo of child welfare for Black, Indigenous, and other families of color in the district. The bill does not make any major changes to limit the trauma and harm done when enduring a CFSA investigation. I hope CFSA leadership and staff took to heart the experiences shared during the public hearing for this bill and is actively and intentionally looking for ways to avoid children and families from the horrors that others have and still do experience when interacting. I'll note, as it was introduced by the executive, that CFSA supports this bill. Is there any discussion? I will now move B25-0243, the Child and Family Services Aging Investigation Completion Amendment Act of 2024, with leave for staff to make technical conforming and editorial changes. All those in favor, please indicate by saying aye.
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 All those opposed, please indicate by saying no. In the opinion of the chair, the ayes have it and the motion passes. Finally, we will turn to B25-0952, the Luggage for All Youth in Foster Care Amendment Act of 2024, also known as Lisa's Law. I introduced Lisa's Law along with Council Members Trayon White, Councilmembers Bonds, Pinto, Parker, Nadeau, Henderson, Gray, and Robert White on September 16, 2024. This committee held a hearing on November 7, 2024. The premise for this bill is simple. No youth entering in or leaving foster care should ever be forced to use trash bags when moving their personal belongings. This bill is named for and inspired by the advocacy of the district resident Lisa Cohen, who grew up in the foster care system. During Lisa's journey through 13 different foster care placements, Lisa remembers only one when she had a proper bag to transport her personal belongings. Every other time, she was forced to use trash bags, which sent a message to Lisa that not just her belongings, but she herself was disposable. While the use of disposable bags is fortunately not as commonplace as it was during Lisa's time in foster care, we are moving this bill today because one youth using disposable bags one time is still one time too many. Lisa law safeguards against the use of disposable and trash bags in several ways. First, CFSA must provide new or slightly used luggage to youth who are entering foster care, moving from one foster care placement to another, starting higher education or military service, or exiting foster care. The committee defines slightly used to mean in a state of condition that indicates only light previous usage, does not have any major physical alterations, and is not damaged in any manner that inhibits proper function. The committee included this narrow definition to ensure youth receive only high quality and functioning luggage, even if it was previously used. Second, CFSA must establish, inspect, and maintain an inventory of new and slightly used luggage. Third, Lisa law establishes provided luggage will be the property of the youth and cannot be taken by CFSA or individuals with whom the youth is living. The provision guarantees no matter the circumstances, youth in care will always have something that truly belongs to them and only them. CFSA must also consider among the agency's existing supply of luggage the following factors: the youth age and mobility, the number and size and weight of personal belongings to be transported, and the youth's personal preference. CFSA is also authorized to solicit, receive, and accept donations of luggage, and CFSA must document when luggage is provided and when disposable bags are used and why. Finally, CFSA must issue rules to implement the bill that prioritize easing the ability of children, agency employees, and community partners to access luggage. I want to thank CFSA for their support and collaboration during the entire process of getting Lisa's law to the point it is. And I want to thank everyone who testified during the hearing we held, especially Lisa Cohen. And with that, I will now move and open the floor to discussion on B25-0952, the Luggage for All Youth in Foster Care Amendment Act of 2024. Is there any discussion on the bill or the committee report? All right. Seeing none, I will move the law with leave for staff to make technical conforming and editorial changes. All those in favor, please indicate by saying aye.
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 All those opposed, please indicate by saying no. In the opinion of the chair, the ayes have it and the motion passes. Thank you to my colleagues for taking the time out of your schedules to be here to have quorum and for getting this done. I truly appreciate it very much. With that, with the business before this committee having concluded, the time is 3:47 p.m. and this additional meeting of the Committee on Facilities and Family Services is adjourned. Thank you.
Thank you.
Thank
Madam
you.
Chair, you have me marked as present and voting?
I do, but I will
Okay.
say it for the record, Councilman Robert White is present and has voted. Thank you.
Thank you.
Thanks, guys.